Now, acts of God and force majeure. Now, there is an important distinction here, and sometimes what is actually a force majeure in, for example, a German contract is falsely translated as an act of God. Now, there's a difference. A force majeure is anything that happens that can be unforeseen by the parties, that is completely out of their hands, and that causes the end of the contract or causes the contract to be breached. For example, it can be an act of terrorism, an act of war, it could be a military coup, it could be something like a natural disaster, extreme weather conditions, and these are examples, the latter two. These are examples of an act of God. So an act of God is a particular type of force majeure. If I can't carry out the contract because, let's say, we are contracting to sell a car and the car is struck by lightning, then that's an act of God. There's nothing that either party could have done to prevent that. So an act of God is a type of force majeure. Damages is a remedy. It's what you are asking the court for when you sue somebody. So let's say we have a contract, there's a breach of contract case. I contract with you, you failed to fulfill your side of the bargain and that cost me money. I would sue you for damages. And damages is the legal English term for what is sometimes referred to in more general English as compensation. Compensation has a much more general meaning. It's anything that I can do or someone can do to make up for a bad situation they have caused. Let's say I've been caused an injury. I can maybe get compensation from someone's insurance company, but damages is a specific remedy. It's a specific legal English term. So if I go to court, I'm suing you for breach of contract, I'm suing for damages, let's say 1,000 euros in damages. I'm being compensated, it's a form of compensation, but the technical legal English term is damages, and notice it's damages. The first term, counterpart, means duplicate or copy, and as a lawyer, or even as a law student, if you are familiar with contracts, you will see at the end of contracts that this agreement has been signed in two original identical counterparts, of which each party has received one. It's sort of standard closing language in a contract. All it means is each party has received a duplicate or copy of the original contract. Counterparty, on the other hand, means one party to a contract transaction, trade, etc. Another way to talk about a counterparty is to talk about the opposing side. For example, in a transaction, there's a buyer and a seller, and they would be on opposing sides or counterparties. A sample sentence here would be, both of the counterparties are required to sign the contract in order for it to be valid. Damage and damages. This is a mistake of two terms that people mistake on a regular basis. Damage is a harm or injury to a person or property. Damages are the monetary compensation awarded by a court for the damage. So one classic example that many of us have probably heard of for damage or damages would be the infamous McDonald's hot coffee case, in which Stella Liebeck spilled some hot coffee from McDonald's on her legs and she suffered third degree or full thickness burns to her skin, and so this was the harm or injury to the person. She then sued McDonald's for damages, and that is the compensation that she wanted to make up for her harm or injury. The court awarded her damages to compensate her for the harm, the physical harm as well as the medical expenses that she had incurred in order to treat her injuries. This is what was commonly referred to in the press as the $2 million hot coffee case. Of course, it wasn't actually that much in the end because the court reduced the jury's award. But in the end, Stella Liebeck did receive monetary compensation, damages for the harm incurred as a result of spilling the hot coffee on her legs. Hello again. Today we are going to speak about legal doublets. A legal doublet is a standard phrase consisting of two or more words used frequently in legal English. Such phrases couple terms which are similar in meaning, for example, like a synonym. Many times the origin of these doublets can be attributed to the transition of the legal language that you had from Latin to French to English, so a lot of these words just carried on and they were paired together. Nowadays, many modern scholars think that we should do away with the doublets because they are unnecessarily redundant. Nevertheless, they still exist, so it's important that you recognize them and you're able to utilize them for purposes of interpretation. One good example of a legal doublet is due and payable. Due and payable simply means that it is payable, that is, it is due to be paid. Naturally, these words you see a lot of times in contract terms, they go together although meaning the same thing. Another example is final and conclusive. Again, final and conclusive simply means to put an end to a debate or question. Something is final, it's conclusive. You have concluded it. Again, synonyms. Redundant but nevertheless seen and used together a lot within contracts. Another example is legal and valid. A valid contract is one that has been executed in accordance to the requisite legal formalities. It conforms with legal formalities, so if it's valid, it is legal. Again, two words that mean the same thing in contractual terms but are often seen together in a doublet form.